Welcome back to Canadian Justice, where we're discussing sports stars' sexual assault and non-disclosure agreements. We're now also joined by two legal experts on this topic. Julie McFarlane is a professor at the University of Windsor School of Law and co-founder of Can't Buy My Silence. And Howard Levitt is a Toronto-based lawyer with Levitt Sheik. Howard has a conflict in the Hockey Canada dispute and cannot comment directly on that case, so we'll focus mostly on the issue of non-disclosure agreements. Professor McFarlane, I'll start with you. You have been a vocal critic of the use of NDAs in sexual abuse cases, and you founded the organization Can't Buy My Silence, which campaigns to end the use of NDAs in those cases. So can you explain your position to us?
Yes, thank you, Christine. And can I just make a correction right away? I am no longer a professor at the University of Windsor Faculty of Law. I resigned my position in disgust at their use of NDAs in relation to someone who was a danger to students. And that's why I have founded Can't Buy My Silence with Zelda Perkins, who you may recognize. Her name was the first woman to break her Harvey Weinstein NDA. She is the UK side of the operation. I am the Canadian side of the operation. And I also want to clarify, although we are talking here about the use of non-disclosure agreements in cases involving sexual abuse or sexual assault, in fact, the campaign is interested in a much wider misuse of NDAs than that, because these are now absolutely epidemic in workplace settings. We have research, multiple sources of research now, showing that approximately 1 in every 3 employees has signed some kind of an NDA. And typically, Christine, what happens is you come forward with a complaint about sexual harassment, about discrimination of many, many kinds, about perhaps abuse or bullying in the workplace. And in response to your complaint, you receive a severance agreement. And as I will demonstrate in response to what I'm sure Howard's going to say, a pitifully small severance agreement in most cases, plus a non-disclosure agreement. So these have become the default now for dealing with workplace complaints, but also many other kinds of civil complaints. And I'm happy to give many other shocking examples.
Now, Mr. Levitt, you have negotiated hundreds of non-disclosure agreements, and I'm sure you have a very different perspective on them. So why don't you share it with us? What is your perspective on the role of NDAs in sexual abuse cases and in the other types of cases that Julie described?
Well, my perspective is that Julie's perspective punishes the victims. And when an employee comes to see me and I negotiate $1 million settlement or a $2 million settlement or a $3 million settlement, not a pitifully small severance settlement, the severance value of that case might be 10% of what we negotiate. And the other 90% is for the NDA, because the company has done something embarrassing to that company, something that's going to damage that company's brand, something they got to make sure no one finds out about, and they're prepared to pay for that. And so the woman or man in question gets real compensation. And if they did not sign an NDA, there'd be no value in it for the company. They paid them the wrong dismissal damage, which is a pitiful portion of the negotiation that I obtained for these victims. So re-victimizing them if they weren't able to get an NDA.
Christine, I need to get in here because I'm afraid that what Howard is saying, and I know he said this many times before, is completely unsupported by the facts. We have data that shows that most of these settlements are for extremely small amounts. We're talking about sexual harassment and discrimination and bullying within what is usually a precarious, marginally stable and poorly paid industry. For example, this kind of behavior, as I'm sure everybody listening must realize, is endemic in industries like hospitality, accommodations, retail, and so forth. So not even thinking about sports organizations now. Yet those workers, when they make a settlement, they are being compensated for what was done to them, the harm that was done to them. But we have data that shows that, for example, for pregnancy discrimination, 20% of people get less than $5,000 in those cases. In sexual harassment cases, we have data from the US showing that the average settlement for sexual harassment in the US, and this is the Employment Opportunities Commission, Howard, this is real facts, not just blustering, The average settlement is $25,000. And to say that people are only getting money and you can get them $1 million if there's going to be silence is just not true.
Well, Julie,
Even if it was true, I think that most people would feel that covering up a perpetrator and allowing them to continue to do what they've already done over and over again is an
Professor
immoral
McFarland,
thing to be facilitating.
A hot topic. We've got to go to break, but we will continue this after.